Yep.
Okay, I'm going to transfer you to Matt. He said he can answer all those
This
questions.
is a public service.
Yep.
Okay.
This is Matt.
Hey Matt, it's Lane Myers. I called up there to just to see what's going on with this whole reclusal and all this.
Yeah, so I don't have a whole lot more information than you do. We got the notice yesterday. Judge Cranshaw recused himself from the 2 disorderly conduct cases that involved the incident at the auto parts store. The disorderly conduct case that resulted from the mayor and council meeting is being sent to justice court. I assume the reason being that because the city of Tucson, obviously from Tucson City Court, appoints the Tucson City Court judges, they thought it was better to have Pima County Justice Court handle it.
Yeah, but that should have happened. That should have happened before I made my disclosures. Somebody's getting in big trouble. You don't get to get all my disclosures. So are you still the prosecutor? Are you going to be taking the case in Superior Court? You're going to be taking the case that got transferred to Pima County. You're still the prosecutor.
So, to my knowledge, I'm still the prosecutor on the cases that are going to be in city court. I don't know if their intention is for a member of our office to continue to prosecute cases in justice.
They told me no. They told me that they are.
Who told you that who is?
When I called Pima Justice, they said they don't use city and I'm like, well, I thought you would still be the prosecutor even though the case got moved to Pima County Justice Court. They said that they have their own prosecutors.
Yeah, so I assume that I will continue to be the prosecutor even though the case is in justice court. It's just going to be heard by a different judge.
That's fine then, because if not, it needs to get this.
About all this yesterday, and the judges didn't.
Because if not, the case you need to move for immediate dismissal. Because then I gave the city the victim all the evidence, and then if you stay on as the prosecutor, then it was okay. But if you don't continue on as the prosecutor, this case is completely gone. Because it's gone anyways, but this is just another reason. You can't take the disclosure and then disclose a conflict of interest. You need to disclose the conflict of interest before I disclose the evidence.
So, just a couple points on that. I'm not asserting that the city prosecutor's office has a conflict. This is a court decision.
It says Walker.
Motion with the court. Sir, just let me finish my sentence, please, okay? So you're entitled to file any motion with the court. Court unilaterally made this decision. We did not request it.
I know.
Likewise, if it is in justice court, you're entitled to any motion with them. That's all the information I have. I have as much information as you do, Rick.
So you got this same email because I'm trying to figure out why it says Walker, because I know you didn't move for this. And so why does it say Walker? The undersigned recuses himself from these cases.
So the way Judge Cranshaw does his minute entries, and I know this because I was in his courtroom for years, is he just puts the last name of the attorney. So in that case, it would have been me, the prosecutor. So all he did was just stick my last name on it. Doesn't mean that I'm the one that's...
So that's not like quoting Walker. That's not attributing to Walker. That's just CCing Walker type thing.
Basically, yes. Yeah.
Okay, so he recused himself and vacated the trial, but I didn't ask for a continuance, and my 180 days doesn't stop, even though he wrote on here, a continuance requested by defendant, extraordinary circumstances, continuance granted, time is excluded. I didn't ask for a continuance, so this whole thing is moot. So I don't know why he put that I requested a continuance, and I'm talking to the Josh Helberg. He's trying to figure out, he's going to go try to get an answer from the judge, because I did ask for a continuance of the July 11th pretrial, but I also filed a motion to withdraw that, and then the pretrial took place, and he set this September 30th trial. So I'm trying to figure out, you're saying, no, you didn't ask for it, I didn't ask for it, but the piece of paper attributes this whole vacate and all this to me requesting it. I didn't request it.
So I don't disagree with you, sir. So, like I said, I found out about this probably at the same time you did.
Right, yesterday at 1 in the afternoon. You know what I mean? So so you don't got any more information, because I didn't. The reason I knew it wasn't you, because I didn't see a motion from you on the docket requesting. Why would you? So it's two separate things here. The O'Reilly case is staying with the city court, and it's going to be changed to Judge. I think it's Miss Mayhew and
Judge Mayhew. Yeah.
But the trial, but it's saying the September 30th trial is vacated, well, why would it be? Now, I can see we don't get to control the judge recusing himself. You know, we don't get to go inside his mind. But what happens after that is as far as I'm concerned, and that's what I'm talking to you too, is that, okay, the case that's staying with you, or, you know, with Tucson City Court, continuing with you as the prosecutor, I feel like that should be transferred over to Judge Mayhew, and the only thing that should change is the name on the docket, not the date of trial.
So I'm inclined to agree with you. I imagine the reason that happened is because Judge Cranshaw does not control Judge Mayhew's calendar and vice versa.
Right, they could have already had something. I get it. Right.
So, yeah. So I understand your clock is ticking as far as your Rule 8 time, and we set a trial. So, you know, but if you can believe it or not, we're basically on the same page, I think.
I believe that being on the same page. I'm just trying to figure out, because so you, Matt Walker, didn't file something saying this is a conflict of interest in the counsel case.
No, sir.
That's what I'm saying. So who did that originate from Chambers?
So I'm assuming that Judge Cranshaw had some kind of discussion with the presiding magistrate that is Judge Close. They had a conversation about something having to do with whatever reason Judge Cranshaw recused himself from the cases that were before him that are now with Judge Mayhew. I don't know why he did that. And I'm assuming the reason the other case went to Justice Court is because it was in front of mayor and council. That's just my assumption.
Right, that's your hypothesis, right? You're just saying that as your hypothesis, not necessarily based on some concrete information that was given to you or some rule of procedure. Because what I'm saying is we can only take this at face value. That's all we can do. And so what I'm trying to figure out is, okay, so the case that went to Judge Mayhew, that wasn't a conflict of interest, but the one that went to Pima County is a conflict of interest. So if we go with your hypothesis of it being, you know, but what I'm saying is then why, and I'm not calling you out on this because I'm not even sure normally this is like, my wife's a law clerk at the federal building, like, I know that, like, the clerk has to look into the conflict of interest before they even assign the docket. So, like, I'm saying, and I'm not questioning you in a tone of I'm accusing you. I'm just questioning you, like, okay, how could it get past the pretrial disclosure before the conflict of interest is discovered? That kind of is like the whole reason of a conflict of interest is to avoid situations where, like, I'm turning over evidence to the victim and then, like, you get what I'm saying? And so, like, that's the whole rule. Now, and you're saying it didn't originate from you. You didn't flag it up as a conflict of interest. But if you're saying your hypothesis of it being with the city and the mayor and all that, my question for you was, and I'm not saying that in, like, you're guilty, I'm saying then why didn't you bring that up immediately before all this?
So my opinion is that there is no, look, I'm going to be careful how I say this because I don't want you to think when I'm saying this that I'm implying that they did something, unethical, illegal. I disagree with the judges all the time. I disagree with them about many of their rulings in cases that have nothing to do with you or anything else. So for me personally, a conflict of interest means something different. I don't necessarily feel like there is a legal conflict of interest to the judge to move the case to...
Based on your hypothesis of it being the city council, I agree. Like, I feel like a fair and biased judge should be able to... unbiased, not biased. You know what I'm saying. That should be able... I'm 100%. So, that's kind of why I'm with you on that. Like, okay, I don't think but now remember... We are not him. We're just taking it at face value. So your hypothesis of, okay, he might have had an internal and said, oh, the city council and all that. And what I'm saying is that, well, I don't, if that's the reason, I think, so you've already stated from your end, and I agree with you, I don't think that's valid of a conflict. I don't think that would, because the reason, and you know, you have your position of why you wouldn't think that's a quote-unquote legal conflict of interest. And I have my position why I don't think it's a legal conflict of interest. But on top of that, I would say that whatever legal conflict of interest they determined, it would have been there when as soon as I got arrested. And so how did it get to this point to where they internalized this is a conflict of interest? And I'm saying, so it's like, So we can only take it at face value and then react to it. You know what I'm saying? And our hypothesis is, oh, it's the mayor, the city council. Well, I don't think that's a good enough excuse. And if that is the reason, then it should have been brought out sooner. That's my position.
So you're entitled to file an objection to that. I'm not going to be objecting.
Objection to the moving of it? You mean to the objection to move it?
Yeah, you can
right,
file
right. No, I know. I see what you're saying. Right.
So, but as far as your other question about, that there's been disclosure, et cetera. So the way it works, and again, you can believe me or not, a couple different principles of law here. The Justice Court and the City Court are both entitled to hear cases that originate within Pima County. So the Justice Court has concurrent jurisdiction with Tucson City Court over these matters. So cases do get moved back and forth, with some regularity. The second thing is, until a judge has made any firm decisions in the case, there's no prejudice. So it's not as though Judge Cranshaw has made a bunch of adverse rulings to you and then decided to transfer the case. He hasn't ruled on anything.
He actually did, though. Can I pump the brakes for a second there? That's what I'm going over. This is an adverse ruling because this order says defendant requested a continuance and he's excluding me. So he's saying that my time stopped and you could take 2 years now to give me a trial. I did not waive my right to a speedy trial, and that's what I'm saying. This is a order, and that.
You want to do this? You can file something. You can put this in there if you want. You can say that you're not waiving your right to a speedy trial. You can tell them that you consulted with the prosecutor. The prosecutor's fine with that. We understand that you didn't waive your right to a speedy trial. Or the thing is, courts can retroactively include or exclude time. So when this case does end up in front of Justice Court next time, or wherever it goes, we can make a record that you are still invoking your speedy trial rights, and we have 6 months to bring the case to trial.
No, I get what you're saying. Right. No, I get it. We can always, right. We can, but what if they take more than 6 months to give me, because once they click that, they're not on the clock. And so then their computer giving me a court date, they might be like, oh, and the court date might be outside the 6 months.
So at that point, you could file a motion to dismiss under Rule 8.
Right. No, I know what you're saying.
So there you go.
So look, and there's and we can agree on this. I don't want to get petty, but okay. So you're saying he hasn't made an adverse ruling. I believe that he did give me an adverse ruling by calling her the victim when it's listed in the reports as a witness, and everybody I've talked to, including the police department, the arresting officer, the videos, everybody I talked to is going to testify she's the witness, not the victim. So I don't know where you came up with that. I don't want to argue with you about it right now, but I'm telling you that I got to call you out on that in paper, in filings, because that's not what the police report says. That's not what the officers are going to testify. That's not what the Tucson Police Department's going to testify. That's not what O'Reilly Corporate's going to testify. That's not what MJ Raciti told me on the phone. But like I said, you have your position. So what I'm saying is that this is adversarial because he said that it's excluded in all this, and I have no way now that it's moved to the Justice Court to file a motion on this case in the City Court and object to Mr. Cranshaw's ruling because the case is now in Justice Court.
So you're going to get something from Justice Court. It's going to have to be sent to you. They're going to have to tell you who your new judge is. They got to tell you what your next court date is. So you are free to revisit that issue once you get that information from Justice Court with the new judge.
But I'm going to be time barred.
Your favor is now. So real quick, just let me finish my sentence. It actually works in your favor now because you get a second bite at it. Right now, you get an opportunity to talk to another judge and explain why your position that this person is not a victim. So you actually get a second chance at it. Okay?
Well, you're saying under the premise that when they take us over to Justice Court, that they're going to give us a pretrial instead of just. So to me, okay, and I believe that you already stated that, we agreed at the pretrial in front of Judge Cranshaw. We were both cool with September 30th, right? You didn't object to September 30th. I didn't object to September 30th. So as far as I'm concerned, if they want to send it to Justice Court, that's fine. Just make it September 30th. But then I understand from the perspective, like you said, the logistics might be they might already have something in Justice Court scheduled on September 30th, so they might have to move it, give or take.
I'm sorry. I'm conflating your two cases. You can revisit with Judge Mayhew, because I'm sorry, those cases.
Right, Judge Mayhew. That's what I'm saying. Judge Mayhew. Right. That's the O'Reilly victim thing. The O'Reilly thing, the victim, the witness, all that. That's with the O'Reilly. That's gonna still be over there. As far as I'm concerned, that case should just go from Cranshaw to Mayhew, and the trial's still on the 30th, and the motions I already filed, and the things you already disclosed, and we're still moving along. We don't need, you know what I'm saying? Everything, just change the name of the judge and change the courtroom. It might not be September 30th, but maybe around then, give or take, you know what I'm saying? And the whole motion, the victim, right. I can file, dismiss, you know, dispositive, all that. I have that access with Judge Mayhew regarding the whole, is Mackenzie, all that. But I'm talking about the one with the city council. I can't object because the case is no longer there.
Well, yeah, I mean, again, look, I don't entirely disagree with you. You can either try to file something in city court, or once you get something from justice court, you are entitled to file another motion articulating your position. Okay?
But you can just argue that it wasn't filed within 14 days. Like, if I want to object to something at that hearing, I have 14 days to do it.
So I'm not, listen, sir, you can have whatever opinion of me you want to have. I'm not going to trip you, okay? So if you want to file something that says you're objecting or whatever, you know, I'm probably not going to, if it's strictly to move the venue or to change venue, or you're saying that it was going to properly move to justice court, I don't know that I'm going to take a position on that. Quite frankly, I don't know that I really care.
Oh, I'm not objecting. I'm not objecting that. I don't care if it was moved. Here's my primary concern, that this piece of paper says that I asked for the continuance and that it stopped my time. I don't care if they move it to justice court. My only concern is if they move it to justice court, you're still the prosecutor, and I don't care if they move it there. I don't object to that. I would object if they change prosecutors and then all the evidence I gave you just disappears. But I would in the moving it from Judge Cranshaw to Judge Mayhew, I don't object to that. I do object to them not having the trial on September 30th and somehow pinning it on me like I asked to do that. I didn't do that.
Sure. So you can, wherever the case lands, okay, if it's the one in front of Mayhew or whatever, we can make a record. You're free to email me.
I know.
Give you my email?
I know, but I don't want to blow you up, dude.
You're free to email me.
I don't want to blow you up. I know.
Look, this is my job.
I know, but I can get emotional sometimes and send frivolous emails, and I'm trying to save it for productive emails. You get what I'm saying? And I was getting some productive emails ready, and then I got hit with this. So, like, I believe we were both on the same page pointing towards the 30th. You know, we'll figure it out in court. I don't need to call you every day on the phone and try to litigate the case. You know what I'm saying? It's like, well, I got a trial, but then now this kind of just, like, throws everything off where it's like, hey, bro, like, I didn't agree to this. I don't know why he's saying defendant asked for a continuance and gave up a speedy trial. And so, like, you and I need to get on the same page with that. I didn't ask for that.
I understand. Send me an email, and I will give something back to you in writing that says I agree with your position on that. Okay?
And where do you believe? Not giving me legal advice, but where do you believe that that's filed? Try to file it with clots in the city, or wait till county and give it to county.
So for the case that's staying with city court, just file it once you get something else from the new judge.
Right.
You get a piece of paper from the new judge, file it then. Same thing with justice court. Once you get something from there, because you don't even know who it's going to right now. You don't even know what judge is going to.
No.
They don't probably.
They have no record of me over there. They have no record of my case at the justice court as of 20 minutes before I called you.
Yeah, just wait, and then you'll get something from them, or I'll get something, and if I do, I'll reach out to you, and then we'll go from there, okay?
Okay, so I mean, I'm an honest guy, even, like, anything you say and all that. So you're saying you don't think, so if I was to, like, start digging into this, and to try to figure out so Matt Walker says, I didn't file anything, I didn't approach them saying this is a conflict of interest, right? And then I'm saying, well, what's the conflict of interest? Articulate it, Your Honor, or somebody needs to explain what the conflict of interest is. And you're saying if they were to say, it's because it involves the mayor and the council, your position would be you don't think that's a conflict of interest.
Correct. I don't. Conflict of interest, I could probably talk about this for a while. I could speak at length on it. I've done lots of research into it. I've litigated it. Whether and to what extent it is a true conflict, the judges want to avoid the appearance of impropriety, okay? So what they don't want to happen is because Mayor and council appoint Judge Cranshaw, right? They pay his bills, they sign his checks. So what they don't want to happen is Judge Cranshaw only found Lane Myers guilty because mayor and council are the ones that are signing his checks. Now, I don't think that's a true conflict of interest. I think they're trying to avoid the appearance of impropriety. That is
You're trying to say that if somebody was to try to make that, like, I'm not going to be clear, I'm saying this is a hypothetical argument I'm going to make against your proposed, what you just proposed, right? And you're saying that would be the position, that would be your position relative, if anybody, Lane Myers, a defendant, a position, a party, an attorney was saying, hey, you can't take this case because of the reasons you just said, your position would be, you would object to that and say, well, if we really want to break down the nuances of all that, then every case is, because he appoints her for every case, and so like her neighbor, her everything, you could, if you really want to go down the rabbit hole, every single resident of the city of Tucson has a conflict of interest, and you know what I'm saying? And so
you're not wrong. That's why I don't think it's a true conflict.
And that's what I'm saying. And so if it was what you were saying, then that should have been like a policy of the court, like a local rule, for lack of a better term, an administrative procedure at your court, where automatically any case involving that automatically goes to justice court, and we never even appear in city court. Judge Cranshaw doesn't even know about the case. He doesn't have a pretrial. He doesn't take dents. No evidence is presented because it's a standing conflict. You know what I'm saying? And versus, well, in this case, what conflict arose in a few, we were going to trial, and it's like, now the conflicts arise, like, where, and I realize it's self-reported, but I'm trying, and we're just hypothesizing why it took this long, or did something, like, because, like, if what you say is true, it's the mayor and the council, well, it was the mayor and the council since I got arrested. And what you're saying is now that's why I wanted to question you directly, because I'm going, well, Matt, if it's a conflict with the city and the mayor, then why didn't you bring that up as soon as you saw the case and say, hey, we can't take this case? And I see why now, because you're saying it's not a standing like thing over there. There's not a standing policy to
my knowledge.
Right. That's what I'm saying. So it wasn't like, a default thing where like, it's the mayor and council, conflict of interest, no object, we don't even discuss, for it to get to this point, and it leaves like, okay, the door open for questioning, like, what took so long?
And I don't know. So real quick, sir, I think this has been a pretty productive conversation.
Yeah, for sure.
But I do have another commitment.
It's all good.
I do have something else I got to do here in a few minutes, so you're free to send me any email you want to send me.
I will.
Don't worry about blowing up my,
No, but you know what I'm saying?
I understand we're in an adversary relationship.
It's all good, though. This is business, bro. This is business. I went to the meeting to get arrested on purpose. This is business. This is bigger than, I'm trying to set case law. Like, it's not me versus Matt Walker. I'm telling you.
Okay. I agree with that. So feel free to send me any email you want, and, once I get more information, I'll share it. Okay?
Yep. I appreciate it. Have a good one, man.
Okay.
Thank you.
You too.
All right, bye.
Included time. When you file a motion to continue,
I did not file. This is the bullshit, sir. There's no fucking motion filed by me to continue, and that's the bullshit Cranshaw tried to pull. The last judge tried to pull. I did not file a fucking motion to continue anything. I filed one before my 11th pretrial. I then withdrew that motion. It was ruled on, withdrew. I showed up at the fucking hearing. Cranshaw wrote that shit on there. I filed a motion showing that wasn't true. They didn't fucking hear it because it said bullshit. You better not, sir. You better not come in here and state into that fucking microphone that I filed something to continue my trial. That will be the misconduct commission complaint that you can't fucking read. I did not continue shit. Pull the fucking motion out where I asked to continue my trial. Every fucking day in this case is included. Don't pull that bullshit. I don't give a fuck what you got to say. Look at the record. Read the fucking thing. It says that I filed a motion. Show me the fucking motion where I continued my trial. Show me it. Pull it out. It's in the file. Pull it out. Walker, pull it out, bro. Pull it out. Pull out the fucking motion that I filed to continue the trial. But that's what I'm saying, sir. You don't get to make the law up. You get to follow it. I just read you why you're breaking the law, and you looked me dead in the face. And he's not allowed to sit here and talk bullshit.
Everything I've said it might be loud, it might be obnoxious, but it's legally based. He's trying to bias the jury. You just sat here and looked me dead in the face, sir, and said that time included. Oh, you obviously haven't done your research on this case. Clearly haven't read the record. You're just going off the fucking surface level bullshit. You saw something in there. Just because Cranshaw claims I filed a continuance to cover his ass, that doesn't mean I filed the continuance. Walker didn't file a continuance. Neither one of us moved to continue the trial date. I have emails from him stating he doesn't know why it was granted. He didn't move to continue. He agrees with me. It should not be continued. So I could show you an email from the state saying he wanted this.
So we can just move on. I agree that Mr. Myers has never filed a motion to continue. So can we just move on past this?
So we could just move on past the fact that the law says if no motion to continue is filed, you have to dismiss with prejudice, because unless you do it with if neither one of us moves, the only way you could do it is something signed by the Arizona Supreme Court Chief Justice saying you're suspending Rule 8. Neither one of us said this. You just said time included. There's no suspension of Rule 8 here. Every fucking day, second time since I've been falsely arrested is counted in this case. Where's the fucking arresting officer? Sir, so right now you need to tell him he needs to produce the officer for an interview. They won't fucking give me the officer that arrested me on the side of the road, put me in the cop car for an hour and a half. They will not make him available for a pretrial interview. We know he's not the victim, other than a victim of his own stupidity for arresting me and getting himself into this. Where's the fucking witness? So 105 days in, they won't give me the witness list. They won't produce the arresting officer. They're lying to you about the case being continued. You don't have time to have a fair trial. We're at day 106. You have till day 180. That's tactical advantages. I've read all the Supreme Court case law. They're doing this to gain a tactical advantage that gives you the power to dismiss it with prejudice. I can show you the fucking case law just like I did in my motion. See, I'm arguing from the Supreme Court. He's arguing from his feelings. The Supreme Court of Arizona, sir, is ultimately going to be the arbiter of your decisions. And that's what I'm telling you. You better think twice before you violate Lane Myers. And that's not a threat, sir. I'm going to apply the law to you just like you. So this case is, I'm charged with 2 counts or whatever for her lying bullshit. Well, he thinks that I'm being prosecuted for whatever this charge is. And I'm standing here saying, all I see on this ticket is, and the judge's career, and the prosecutor's career, and the officer's career. So there's a conflict of interest with all of us right now. Because it's not even a conflict of interest, though. It's a conflict of intent. The intent by this prosecutor is to get off some charges to prevent the officer being sued from unlawfully arresting me. Otherwise, why wouldn't he make the officer available? Why haven't I been able to question my accuser? Why did the man that held me in handcuffs, sir, and the most disturbing part is, while being in handcuffs on the side of the road for an hour and a half, the cop looked me dead in the fucking face, and you're going to see this on his body cam, and he said, a jury's just 12 people too stupid to get out of jury duty. And you're right. The judge might dismiss this case, but you got to deal with me fucking with you tonight. This fucking cop said that on the body cam, for the whole world to see, and he's worried about me releasing it because it looks fucking bad, because before he came and arrested me, Your Honor, he put this woman in handcuffs because she asked him to. The victim was playing BDSM in the parking lot with the cop saying, sir, he walked up. I feel you. I won't use that. I got it. Hey, no, he let her handcuff her. She got to read the police department laptop. Watch the video, sir. Watch the video. I'm not taking it down either. The whole world needs to see what happened to this. The whole world needs to see what happened. She asked the cop to arrest her. They sat there for 45 minutes. The cop said he could beat her. No, dude, there's no trial. You're about to dismiss this case. Okay, well, there won't be no trial with you then.
My turn, Your Honor.
To lie.
Back to what I was saying.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.
To vacate a trial without either party moving, the judge needs to show me something signed by the Arizona Supreme Court Justice saying you're suspending Rule 8. Who the fuck suspended Rule 8? I didn't move to suspend Rule 8. He didn't move to suspend Rule 8. You didn't grant the suspension of Rule 8 because that requires a Arizona Supreme Court justice. How did we get to the point where my trial was vacated and I didn't move to vacate it? He didn't move to vacate it. So why the fuck is it vacated? State law says you cannot vacate a fucking trial unless it's signed by the Supreme Court fucking justice. So what are we doing here, Rojas? This is the 5th fucking courtroom I've been in with this kangaroo bullshit where fucking the law just seems to... We got the hearsay. Not admissible unless you're going to let rebuttal evidence. Just now, talking about anything that's not related to the facts and findings of my guilt is hearsay.
No, it's not.
We could... It's...
That's not the legal definition.
I get what you're saying. Okay, I respect that. It's not... It's gossip. It's fucking irrelevant. Thank you. It's fucking irrelevant. In every courtroom I've been in since this case started, he started his fucking petty bullshit. And his wife's a fucking professor at the school too, right? And this piece of shit got my wife fired from her fucking job, okay? And I can guarantee you, this shit's gonna become way fucking bigger than this court case under your watch. Now let's read the fucking rules about vacating a trial, sir. You can't just vacate a trial without, right here, Rule 8.5. A party may ask to continue a trial, right? By stating the specific reasons for the request. A court may continue a trial only on a showing that extraordinary circumstances exist and that delay is indispensable to the interest of justice and only for so long as necessary to serve the interest of justice. The court must consider the rights of the defendants to a speedy disposition of the case. The court must state specific reasons for continuing trial. Not just put a thing that says your trial is vacated, it's continued. That's not a specific reason. And when I fucking object to it, and she says, oh, you can't put the word bullshit in your order, so I'm objecting to it. Or I'm striking it from the record. So my objection to my trial being vacated didn't get whatever you want to litigated motion between us because she struck it from the record because my motion had the word bullshit. I've said fuck 50 times already today. Why did my motion get struck for bullshit? That's why she was my judge for 3 days. This piece of shit stands at the fucking thing. All right, I'll stop. All right. I'll talk to you. So this unethical prosecutor stood in Judge Mayhew's courtroom after I got kicked out and literally talked into this microphone and said, Your Honor, I'd like to be heard for the record. We're getting the times and dates and times available for our witnesses. We'll let you know when you have trial. So how the fuck does he know his names and times of witnesses, but I haven't even received it? I'm the fucking defendant, and it's been 100 days. So he's telling the court, I have my list of witnesses, and I'm saying, yeah, it was due 3 fucking months ago. So how does he have his list of witnesses? He's telling the court he has his list of witnesses, but the defendant doesn't have the list of witnesses. How can I prepare my trial? How can I interview this moron if you fucking don't give me their name and their information as required under by law, right? So, Rule 15.1b, the state has 30 days from request. I put in a motion to compel fucking 4 fucking months ago. They had 30 days from that motion to give me their 15-1 disclosure, witness list, all that shit. Or by the first pretrial. That's the law, sir. You follow the law. The law said first pretrial, you must receive. I've turned over all my disclosure. They've had all my Rule 15 disclosure, all my witnesses, all my evidence, everything for 4 fucking months. I don't even have the witness list. But they're openly admitting on record that they've been interviewing witnesses, talking to witnesses to get their time available for trial. They're clearly communicating, but I don't have a witness list. How can I prepare? How do I know who's going to be called against me? Due fucking process. And I'm telling you right now, I got a federal lawsuit in a different county about judges that let this kangaroo bullshit done. And I'm telling you, you can read my lips. He will be under 2-year buyer suspension. Play games, and it's going to be you caught in the middle, sir. And it's not, and I'm not, this is how I got to talk, because this is my 5th fucking court date where nothing's happened by the law. So either today it's going to go by the law and you're going to dismiss this shit under Rule 8 and Rule 15 because my right, with prejudice, speedy trial rights, they have nothing. So how are we going to have a trial if they have no admissible evidence because they didn't turn it over by August 9th?
First of all, sir, I can't dismiss the case once you filed the motion.
I have, and they fucking threw it out for the word bullshit. That's fucking bullshit itself.
Have a seat, please.
Don't tell me you can't hear my motion to dismiss because it contains the word bullshit.
I didn't say that.
No, she did, and that's why we already had this hearing a couple weeks ago where I should have got my motion to dismiss granted based on everything I just told you, but instead she ended the hearing and let this man go in there and straight on this fucking microphone say, yeah, Your Honor, the state just wants to know. We're figuring out our witnesses, and when we get it to you, we'll let them know, right? It's literally on the minute entry, okay? So where the fuck is it? And then I sent him 7 emails since that hearing, unreturned. Where's the witness? I call the fucking prosecutor every day. Where's the witness list? Where's the witness? Sir, how can you proceed over due process if I don't even have the procedural due process, right? Pre-deprivation, post-deprivation rights, right? So I have the opportunity to confront the witnesses before me, opportunity to be heard in an impartial trial, right? Okay, well, anything from impartial so far. When Cranshaw said, your deadline to turn in, the thing I'm arguing about right now, Cranshaw said he had till August 9th to turn that in. It's literally in your fucking minute entry that the state has till August 9th for disclosure. Well, we're here at fucking the end of September. Nothing. Not a fucking thing. It's literally in the minute entry from my July 11th pretrial when they set my September 30th trial. Why did Cranshaw, sir, if there's a conflict of interest, you declare that before the case, okay? Up until they got my wife fired, she was a law clerk for a federal judge across the street, right? They didn't even get her fired. She resigned, but you get what I'm saying. So the idea is you follow the law, okay? I know you work for the city. He works for the city. I'm not accusing you of that because I've only met you for 10 minutes. But I'm telling you what's been going on is, sir, how would you let a case move through arraignment, pretrial, set a trial, and then be like, oh, it's a conflict of interest, vacating the trial? Why the fuck didn't you declare it a conflict of interest before we started proceeding in the case? That's bad business. So they threw it to Mayhew, and then she wouldn't let me talk. She let this man stand in there and lie right into the fucking microphone. It's all over my YouTube. The whole world has seen this piece of shit. This unethical prosecutor fucking do everything he's doing, and we know why he's doing it, because I'm suing the cop that did it, and that's her little buddy. She's an undercover informant for the Tucson police, and her mommy fucks the cops.
To stop making a record directing anything to the victim, calling the victim
witness.
Names.
You bring the witness. You get. Hey. Sir. All right. Okay. Go ahead. Okay. He's saying she's the victim. He just lied to you right to your face, sir. I can show you the police report where it says Mackenzie O'Brien, witness. So twisting this shit where she's the fucking victim is their only hope, because then they won't give me a pre-trial interview, because they're saying, and this is why Cranshaw got off the case, because we came in the thing, he said she's a victim. She's not. It's literally, sir, you have the police report, fucking read it. I don't have it. Well, then how do you not have it when I've turned it in my motions? That's what I'm saying, sir. You don't have the police report? Then how are we standing here letting him call her a victim when the police report that I given by the prosecutor lists her as a witness?
He's allowed to claim whoever someone's a victim.
Oh, okay. Well, I'm a victim now. Well, okay. So let me say this, sir. I'll allow you to say that he has the burden's on him to argue all that, right? Okay. So now the burden's on me to show you something. This victim right here. So this incident took place May 20th. Okay. On July 30th, she was posting on her own YouTube channel talking about the case. So how can the victim talk about the case, but I can't talk to her, right? I'm not allowed to contact her, but she's allowed to go on her YouTube and say, Lane's lying. It looks really bad. I know you got videos of me lying, but I promise you I have a video that shows Lane. Sir.
At a trial, when there's a trial, you have the right to present that evidence.
There's not going to be a trial because you're about to dismiss this.
No, I'm not.
Okay, then you're going to recuse yourself.
I'm not going to. Why would I recuse myself? Why?
I'll file the motion. Don't worry.
All right, now.
You'll see.
State wishes to make a statement?
Yeah, my turn, Your Honor. First thing the state's going to ask for is a motion to modify the conditions of release. All these requests are going to be directly stemming from the case. They're not going to impact Mr. Myers' ability to defend the case in any way. Mr. Myers has taken the information the state has provided under Rule 15 and posted on the internet. That's a violation of Rule 15.4.
Don't start. Objection. We're not fucking having.
Sir, he didn't interrupt you. You don't interrupt him.
You better fucking hold it.